Hello everyone, welcome back again to my channel. Before watching this video, don't forget to like, comment, and subscribe. Now let's start this video. Implementation of agreements with foreigners, Part 4. Arrangement with neighboring countries. In 1969, possibly taking the hint from the interim arrangement between Indonesia and Japan, Malaysia took the initiative in concluding an agreement on fishing activities by Malaysian nationals in Indonesian waters in the Strait of Malacca. After some lengthy negotiation, however, the attempt failed to have concrete result because Indonesia was reluctant to apply the interim arrangement system with regard to fishing activities in the Strait of Malacca. Indonesia was, however, prepared to cooperate with Malaysia on the basis of the Indonesian Foreign Investment Law of 1967, Indonesia Law Number 1, 1967, to the effect that Malaysian private companies would be encouraged to invest through joint ventures with Indonesian fisheries cooperative or companies. This idea was not so attractive to Malaysia, and therefore no agreement on fisheries has been concluded between the two countries. The restriction that Japanese vessels should engage mainly in tuna fishing and only by long line method remained. The maximum catch was now reduced to 8,000 t per year, and the number of long line vessels to be used was fixed at maximum of 100, consisting of vessels less than 80 GT class or Class A and 80 GT or more, but less than 300 GT class or Class B vessels. The maximum number of Class B vessels was limited to 35. Likewise, Japanese vessels operating under the contract were required to be pier markings, the details of which were indicated in the contract. The vessels were not also allowed the use of motherships or transporting vessels. One new provision in the contract was the profit sharing arrangement. Under the contract, the association were to relinquish to the PSB 40% of the profit accrued from their operation. The detailed formula for the calculation of the profit was to be decided by both the association and the PSB. The association were to bear all operating expenses incurred in the operation of the vessels, as well as transmit to the PSB reports on the operation and the result, including a profit and loss statement. On the other hand, the PSB was to take administrative steps to obtain necessary documents to facilitate operation and assist the association in obtaining the necessary port entry permit. The Japanese vessels operating under the contract were also required to carry certificates issued by the Indonesian Embassy in Tokyo. The contract was to take effect on 17 October 1975 and was to be valid for 3 years beginning from the date the interim arrangement expired. Again, the implementation of the contract during the last 3 years was not encouraging to Indonesia. The profit from the operation was calculated only at 2.5%. Since PSB's share of the profit was calculated at 40%, the PSB gained only 40% out of the 2.5%, namely about 1% of the total gross proceeds. The amount received by the PSB was not even enough to cover administrative costs such as telegrams, verification, etc. Furthermore, the number of Japanese vessels reporting under the contract was less than the maximum allowable number. While 100 vessels per year were allowed to operate under the contract, only 23 reported for verification in 1975 until 1976. In 1976 until 1977, while 77 applied between September 1977 and June 1978. Between September 1977 and April 1978, only 35 vessels reported for verification and checking at Ambon. Various problems also arose under the contract arrangement. The Indonesian Department of Finance claimed that since the Japanese Fisheries Association and the Japanese crews operating under the contract gained the incomes in Indonesia, they should be levied taxes under Indonesian law. Naturally, the association and the crew refused to pay tax on the ground that they have already been taxed in Japan. The problem was solved only through a dispensation granted by the Indonesian Department of Finance, a situation which was hardly agreeable. Secondly, Japanese vessels were granted bunkering facilities upon entry at Ambon for verification. The irregular, the irregular entry of this vessel created problems for the Pertamina State Oil and Gas Company, which had to make arrangements for the purpose from Jakarta. During 3 years period of the contract, aside from the negligible 1% profit sharing, the Indonesian side also obtained one training vessels along the equipment valued at 1.8 million US dollar as grants and another repair shop for the PSB value at 200,000 US dollar. Since the contract is valid only for 3 years, ending 27 September 1978, both sides are once again faced with the ever perplexing problems of renewing the contract. It is not yet clear how the arrangement will be made, if at all, in the coming years. Strict enforcement of the arrangement with Japan presented many problems. Firstly, the area covered by the arrangement was relatively large, making it difficult for Indonesian law enforcement agencies to supervise. Secondly, other vessels, including fishing vessels, also used the area as a transit route between the Indian and the Pacific Ocean, thus making it difficult for law enforcement agencies to distinguish vessels covered by the arrangement from those that were merely passing through. Thirdly, the enforcement of the arrangement required an improvement in the efficiency of various enforcement agencies in terms of personnel, equipment, methods, as well as coordination. Fourthly, even if the enforcement activities at sea work smoothly, the process of judicial solution through courts will still be monumental. A vessel apprehended at sea for violating the arrangement of Indonesian rules and regulation on fishing had to be brought to be court, which could be 100 miles away from the site of apprehension. A few weeks or even months could pass before the case was finally settled. Financial damage to both the vessel and the Indonesian government, which had to feed the crew during the waiting period, could be enormous. To avoid this situation, since the early 1970s, the Indonesian government issued the peaceful fine system under which a vessel alleged to have violated Indonesian fishing laws and regulation may be allowed to leave Indonesian waters immediately upon paying specified amounts as fines to the Indonesian government through the law enforcement authority that apprehend it at sea. The idea was to avoid lengthy and costly judicial procedure for the benefit of both the vessels and the Indonesian government. Unfortunately, this attempt also met with many difficulties and abuse of enforcement powers was discovered later on. As a result, the system was abrogated. On the other hand, vessels which fished illegally in Indonesian waters were also much to be blamed for the difficulties encountered in enforcing the arrangement. Some of these vessels would rather bribe the corrupt government official rather than stand trial, which in any case would surely cost them more time and money. Various licenses have also been given the Indonesian government to various Japanese companies to fish through joint venture agreements with Indonesian private fishing companies. Dating back to earlier years, such licenses were used in Arafura Sea for shrimp and others. This type of operation was a simple joint ventures agreement within the context of Indonesian foreign investment law. Like all joint venture investment agreement, they were all under Indonesian laws and therefore did not create the same problems. Okay everyone, that's all this article today. Thank you so much for watching this video. Until the next one. Bye bye.